Summer 2025 has ignited a firestorm of changes in Canadian employment law, leaving employers scrambling to keep up. From Ontario's termination clause chaos to Quebec's sweeping legislative overhaul and Alberta's record-breaking notice period, the landscape is shifting beneath our feet. Buckle up, because the rules of the game are changing fast. 1. Ontario's termination clause tango. A legal minefield. Navigating termination clauses in Ontario feels like walking through a legal minefield. You never know when the ground might shift. The saga began with Waxdale versus Swegan in 2020, followed by Dufault versus Ignis in 2024, where courts struck down clauses allowing termination at any time for violating the Employment Standards Act, ESA. But here's where it gets controversial. Henderson versus Ignis. Slavkin had previously upheld for any reason clauses, leaving employers scratching their heads. Fast forward to 2025, and the courts are still split. Lee versus Wayfair Canada and Jones versus Strides Toronto validated at any time clauses, while Chan versus NYX Capital Corp invalidated both at any time and for any reason. The Baker versus Van Dolders home team appeal, with the Ontario Chamber of Commerce intervening, promises more drama. And this is the part most people miss. Even the Birch versus Data Stealth decision, hailed as a model, could face future challenges. So, what's an employer to do? Stay tuned and stay flexible. 2. Quebec's employment law revolution. Quebec is rewriting the rulebook with Bill 101, a sweeping reform set to shake up nearly every workplace statute. Think shorter timelines for grievance arbitration, expanded statutory leaves, and hefty fines for non-compliance. But here's the kicker. CNESST will reimburse employers for reassigning pregnant or breastfeeding employees. While the bill is still under review, employers would be wise to start preparing now. Because when this train leaves the station, you don't want to be left behind. 3. Alberta's skyrocketing notice periods, a game changer. Alberta just blasted through the notice period ceiling with Lischuk v. KJ Electric Limited, awarding a staggering 26-month reasonable notice period, 2 months beyond the long-standing rough upper limit. The court cited exceptional circumstances, including the employee's age, long tenure, and limited job prospects. This ruling is a wake-up call for employers. Enforceable termination provisions and clear policies are no longer optional. They're essential. But here's a thought-provoking question. Are we moving toward a future where notice periods are dictated more by individual circumstances than by precedent? 4. British Columbia's mitigation mandate, a contrarian stand. BC is charting its own course with Max Convenience Stores, Inc. versus Basile, affirming that employees on fixed-term contracts must mitigate losses if terminated early, unless explicitly stated otherwise. This contrasts sharply with Ontario, where no such duty exists. The BC Court of Appeal drew a fine line between the duty to mitigate and the capacity to do so, even for foreign workers on restrictive permits. This decision reinforces BC's practical approach to contractual interpretation, but it also raises a controversial point. Should employees bear the burden of mitigation, or should employers shoulder more responsibility? Ontario's crackdown on non-compliance, the price of neglect. In Carroll versus Oracle Canada ULC, an employer learned the hard way that failing to meet statutory obligations can be costly. The court awarded punitive damages of $57,740.55 for improperly withholding commissions and failing to provide a reference letter. The judge's message was clear. Employees are most vulnerable at dismissal, and employers must act with care. But here's a question to ponder. Are punitive damages becoming the new norm for non-compliance? Or is this an isolated case? The bottom line: these developments underscore the dynamic and often unpredictable nature of employment law. Staying informed isn't just good practice, it's survival. Whether you're grappling with termination clauses, legislative reforms, or notice periods, one thing is certain: the rules are evolving. So what's your take? Are these changes a step forward, or do they add unnecessary complexity? Let's keep the conversation going in the comments.